Welcome back. This is episode 3 of the series covering the complete book, Artificial Intelligence, Neurodata, and Society, Law at the Edge of Cognition by Dr. Mark Leiser, available now from Bloomsbury. In episode 1, we established a foundational shift. AI has moved from predicting behavior to predicting thought. In episode 2, we examined how that shift works technically, the neurodata pipeline, computational inferability, cognitive containment, and the emerging concepts of cognitive liberty and mental sovereignty. Today in episode 3, we enter one of the most consequential and contested applications of neurodata in the real world, criminal justice and policing. This chapter asks what happens when the state uses NeuroAI not to sell you things, but to investigate, charge, and convict you. The stakes could not be higher. The right to a fair trial, the privilege against self-incrimination, the presumption of innocence, these are not abstract principles. They are the foundations of the legal order, and every one of them faces a novel challenge from the intersection of neuroscience and artificial intelligence. This episode follows the same structure as the others, beginning with accessible foundations and escalating to advanced legal and constitutional analysis. Whether you are approaching this for the first time or bringing expertise in criminal procedure, evidence law, or AI ethics, there is content here that will sharpen your thinking. Let us begin. Part 1. Foundations. What does it mean to use neurodata as evidence? To understand the legal challenge of Chapter 3, we need to start with a basic question. What is evidence, and how does it work? Each form of evidence has a different relationship to the fact it is supposed to establish. Testimony is contestable. Witnesses can be cross-examined, their credibility challenged, their memory questioned. Physical and documentary evidence is more stable, but can be forged, mishandled, or misinterpreted. Digital evidence brought its own complications, questions of authenticity, chain of custody, and the difficulty of explaining technical data to lay fact-finders. This is not a hypothetical. Lie detector tests, polygraphs, have been used in criminal investigations for decades. Brain fingerprinting, which uses EEG responses to test whether a suspect recognizes crime-specific stimuli, has been admitted in some jurisdictions. Functional MRI-based deception detection has been offered as evidence in United States courts. Eye tracking analysis has been used to assess a suspect's attention and intent. The question Chapter 3 addresses is not whether these technologies exist. They do. The question is whether the legal system is equipped to evaluate, admit, and regulate them, and whether the constitutional and human rights frameworks that govern criminal justice can withstand the pressure they create. Your first infographic maps the progression from traditional evidence to cognitive evidence. Notice what changes as we move along that spectrum. Contestability decreases. It is harder to challenge an EEG reading in cross-examination than it is to challenge an eyewitness account. Opacity increases. The inferential process that converts a neural signal into a conclusion about intent is not transparent, even to the experts who produce it. And the normative risks escalate because the further you move from observed behavior toward inferred cognition, the closer you get to punishing people for what they think rather than what they do. That last point is not rhetorical. It is doctrinal. In almost every developed legal system, there is a foundational principle. The criminal law punishes acts, not thoughts. Cogitationis poenam nemo patitur. No one suffers punishment for thought alone. That principle is ancient. It predates modern rights instruments, and it is now under direct technological challenge. Part 2, Intermediate Level. The neurodata typology and policing. With that foundation established, we can move to the intermediate level. Chapter 3 introduces a precise analytical framework, the neurodata typology and policing. Understanding this typology is essential for understanding both the nature of the legal challenges and the range of possible regulatory responses. Chapter 3 identifies three categories of neurodata that are relevant to policing and criminal justice contexts. The first is passive neurodata. This is data collected without the knowledge or active participation of the subject. Ambient sensors, covert surveillance cameras equipped with effective computing modules, wearable devices that transmit physiological data to third parties without meaningful disclosure. All of these generate passive neurodata. The subject has not consented to the cognitive surveillance. They may not know it is occurring. The data may be collected in a public space, a workplace, a custody suite, or a courtroom. The third is inferred neurodata. This is the most legally novel and the most dangerous category. Inferred neurodata is not collected directly from neural or physiological sensors. It is derived by AI inference models from other data, behavioral patterns, communication metadata, location data, transaction records, to produce conclusions about cognitive states. A predictive policing algorithm that flags a person as having a high risk of offending is in effect making an inference about their future mental state. A threat assessment system that identifies a person as harboring hostile intent from their online activity is making a cognitive inference without any neurological data at all. Chapter 3 argues that this third category is the most legally urgent because it is the least visible and the least regulated. Your second infographic presents this typology in full. Note the risk profiles. Passive neurodata risks include covert surveillance, lack of awareness, and the collection of data in contexts where constitutional protections against unreasonable search may not apply. Active neurodata risks center on coercion and the erosion of the privilege against self-incrimination. Inferred neurodata risks are the broadest: predictive injustice, discriminatory profiling, and the complete absence of any mechanism for a person to challenge conclusions drawn from data they never knew was being used. Part 3 Advanced Analysis, the AI Neurodata Investigative Mesh. We move now to the advanced level. Chapter 3 introduces a concept that captures one of the most significant structural changes NeuroAI has brought to criminal investigation: the investigative mesh. Traditional investigation is sequential. A crime is committed. Evidence is gathered. That evidence is assessed by investigators, prosecutors, and ultimately a court. Each step is, in principle, discrete and reviewable. The investigator explains what they found. The scientist explains what the evidence means. The jury evaluates the conclusion. The AI Neurodata Investigative Mesh dissolves this sequence. In the mesh architecture, neurodata, passive signals, physiological responses, inferred cognitive states, is integrated in real time with behavioral data, linguistic analysis, social network mapping, and contextual environmental data. An AI system processes all of these streams simultaneously and generates investigative outputs: suspect profiles, risk scores, lead prioritization, and in the most advanced deployments, predictive assessments of future criminal conduct. The legal implications of this architecture are profound. Consider the chain of reasoning. A traditional prosecution presents evidence. This person was at the scene, their fingerprint was on the weapon, a witness saw them. The defense can challenge each link in that chain. The chain is visible. In the mesh architecture, the chain of reasoning is internal to the AI system. The output is a probability score or a risk assessment. The inputs that generated it, including neurodata inferences about the suspect's cognitive state, may not be fully disclosed or may not be disclosable in any meaningful form. The defense faces a conclusion without a chain. The fact finder is asked to evaluate an output without understanding the process that generated it. Chapter 3 calls this the opacity problem in cognitive evidence. It is not the same as the general opacity problem in AI decision-making, though it shares features with it. The cognitive evidence opacity problem is specifically about the inferential leap from physiological signal to mental state conclusion, and about the court's inability to evaluate that leap using conventional tools of legal reasoning. The third infographic illustrates the investigative mesh architecture. Neurodata, behavior, language, and context flow into the AI processing layer. Investigative outputs emerge, but crucially, the legal question the infographic poses remains unanswered by current doctrine. At what point in this process does a lead become proof? At what point does a cognitive inference become legally cognizable evidence? And who is responsible for the accuracy of that inference? The technology developer, the investigating agency, the prosecutor, or the expert witness who interprets it for the court? Part 4. Expert level. Constitutional foundations, evidentiary standards, and the architecture of guardrails. We arrive now at the most advanced section of Chapter 3. Having established what cognitive evidence is, how it is generated, and how it is integrated into investigative processes, the chapter turns to the constitutional and evidentiary frameworks that are supposed to govern it, and to why those frameworks are failing. Let us begin with the privilege against self-incrimination. In the United States, the Fifth Amendment provides that no person shall be compelled to be a witness against themselves. In the United Kingdom, the right to silence is protected under common law and the European Convention on Human Rights. In international human rights law, Article 14.3 (g) of the ICCPR provides the same protection. These protections were designed for a world in which incriminating information resided in the mind and could only be extracted through speech. You could not be compelled to confess. You could remain silent. The state had to build its case from external evidence. Neurodata changes this calculus. If a suspect's brain activity can be read passively without their participation, and that brain activity constitutes evidence of guilty knowledge or intent, is that a violation of the privilege against self-incrimination? Most current doctrine would say no. The privilege protects against compelled testimonial self-incrimination. Physical evidence, blood samples, DNA swabs, fingerprints, is not protected by the privilege, even though it is taken from the body. The courts have consistently held that the privilege is limited to communicative acts. But cognitive evidence is not straightforwardly physical. A brain scan that reads guilty knowledge is not like a fingerprint. It is reading the content of a mental state. It is, in a meaningful sense, making the mind testify against itself without the person's participation. Chapter 3 argues that the communicative physical distinction breaks down when applied to cognitive inference, and that doctrine must adapt. Consider also the right to a fair trial and the principle of equality of arms. The European Court of Human Rights has established, under Article 6, that defendants must have adequate opportunity to challenge evidence against them. In practice, this means the defense must be able to obtain expert evidence, cross-examine witnesses, and test the reliability of the scientific methods on which the prosecution relies. Cognitive evidence generated by AI inference models creates a fundamental equality of arms problem. The prosecution has access to the model, its developers, and its validation data. The defense typically does not. The model may be proprietary, its architecture may be protected as a trade secret, its training data may be confidential. The defense expert, even if available and qualified, may be unable to evaluate the model in any meaningful way. The court is asked to assess the reliability of a conclusion without access to the reasoning that produced it. This is not a theoretical problem. It has arisen in concrete form in cases involving algorithmic risk assessment in sentencing, predictive policing tools challenged under equal protection doctrine, and proprietary forensic DNA software, all in jurisdictions where courts have struggled, with varying success, to apply evidentiary standards designed for human expert witnesses to outputs produced by opaque computational systems. Chapter 3's final contribution is its proposed framework of guardrails, the minimum legal architecture that would need to be in place before NeuroAI evidence could be used in any criminal proceeding without fundamentally compromising the integrity of the justice system. The fourth infographic maps this framework. It distinguishes between acceptable and dangerous roles for NeuroAI in policing, and it identifies the specific legal requirements that must accompany any deployment. On the acceptable side, NeuroAI may be used to generate investigative leads, provided those leads are subject to independent corroboration before they are relied upon. It may be used to assist in the analysis of voluntary submissions from defendants who have given fully informed consent with independent legal advice. And it may be used in research contexts, subject to strict ethical oversight and data protection compliance. On the dangerous side, NeuroAI must not be used to produce evidence of guilt without full algorithmic transparency and independent expert validation. It must not be used covertly in investigative contexts without judicial authorization equivalent to that required for intrusive surveillance. And it must never be used in predictive detention or bail decisions without robust procedural safeguards that include the right to challenge the underlying model. The chapter also proposes 3 specific doctrinal reforms. First, the scope of the privilege against self-incrimination should be extended to cover compelled or covert cognitive data collection on the grounds that cognitive inference from neural data is functionally equivalent to compelled testimony. Second, evidence derived from AI inference models should be subject to mandatory disclosure obligations analogous to those that apply to expert witnesses, including disclosure of training data, validation methodology, and known error rates. Third, the admissibility standard for cognitive evidence should be set higher than for conventional scientific evidence, given the opacity of the inferential process and the magnitude of the rights implications. These are not proposals that current legal systems are prepared to implement, but Chapter 3 argues that they are the minimum necessary response to a technology that is already being deployed. The law is not merely behind the curve, it is operating in a different paradigm. Conclusion and series bridge. Chapter 3 ends with a question that should unsettle anyone who cares about justice. If a machine can read your mind, does the presumption of innocence still mean anything? The presumption of innocence is not just a rule of evidence. It is an expression of the relationship between the individual and the state. It says the burden falls on the state to prove guilt. The accused does not have to prove innocence. The state must show, through evidence that can be tested and challenged, that this person committed this act. Cognitive evidence, as Chapter 3 analyses it, threatens that relationship at its root. It introduces a category of evidence that is generated from within the person rather than from their observable conduct. It is produced by systems whose reasoning cannot be fully explained or challenged. And in its most advanced forms, it reaches backward in time, using inferences about present cognitive states to draw conclusions about past mental states at the moment of an alleged offense. That is not justice, that is cognitive determinism dressed in the language of science. The book does not argue that neuroscience has no place in criminal justice. It can play a legitimate role in assessing competency, in informing sentencing, and potentially in establishing mental state defenses. But there is a categorical difference between using neuroscience to understand a defendant's condition and using neurodata as evidence of guilt. The first is within the tradition of the law. The second is a rupture with it. In Episode 4, we move from policing and criminal justice to employment, insurance, and the private sector. We ask what happens when the same technologies and the same inference capabilities are deployed not by the state with the power to imprison, but by corporations with the power to hire, insure, lend, and exclude. The harms are different, the legal frameworks are weaker, and the scale is orders of magnitude larger. This is Dr. Mark Leiser's Artificial Intelligence, Neurodata, and Society, Law at the Edge of Cognition, available now from Bloomsbury. The link is in the description. This has been Episode 3. Thank you for watching.